They had a solid plan, except they just went off the rails with this one thing. Hi, this is Jeff Marsacci, the Plain English Attorney, and welcome to this video on the anatomy of a destroyed special needs estate plan. Now, this is not as upbeat as some of my other videos where we talk about some of the right ways to handle things. This, unfortunately, was handled correctly all the way through, except the clients did one thing they knew I didn't want. They hid it from me, and now there's kind of some disastrous consequences that came about. So we're going to just kind of jump right into it. All right, so the anatomy of a destroyed special needs estate plan, volume 1, because there may be others that we'll be talking about, or just a destroyed estate plan in general. So my goal for this video is to provide an overview of a single case that was nicely crafted. It addresses all of the client's needs, even evolving over time with some changed circumstances, and showing how just one do-it-yourself move compromised and possibly destroyed the whole plan. All right, so I'm Jeffrey Marsacci, the the Plain English Attorney, doing estate planning for more than 25 years, national lecturer on estate and Medicaid planning topics. Hoping we're getting back into that. There's been a couple of years break with everything going on. I've authored 9 books that are available on Amazon, and I'm the creator and producer of several online courses now available at plainenglishattorney.com. And in fact, the Plain English Attorney series, it's just all of the ones that I've put together. There's access either for an annual or monthly subscription fee. And I'll tell you a little bit more about that at the end. So one story, this is not the main story, but just to show if you want something done correctly, it's not that you go and do it yourself. It's that you get the people who understand what they're doing. It's their profession, and let them do it. So several years ago, I worked with a client, and he knew better. It was more than 1.5 years that I was working with this gentleman to put together his estate plan, and he was challenging me every step of the way, all throughout the document. I don't think this should be written this way. I can make it sound better, blah, 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 blah. And no matter how much I ended up going through everything and listing, okay, here are the ramifications, here are the consequences, this is why this is structured this way. Well, the language sounds confusing to me. It's like, well, because there's a problem, it's not being read by you. You're either dead or incapacitated. It's being read by attorneys and judges and other legal professionals who understand all this stuff. And this is a common thing. Well, why does it have to be so big to say what I need it to say? Well, all right. The legal language, while it may sound convoluted, it may sound overblown, it's because the legal language, legalese, is crafted in such a way that not only is it saying what you want it to say, it's specifically excluding other types of interpretations that someone may try to push in there. So it's not just saying what it is, it's being very clear about saying what it isn't. So that's why legal language sounds convoluted. It's because it ends up actually being very precise by excluding those things. But he really didn't want to hear that. So he was an engineer who had his career now as writing technical manuals for very large pieces of industrial equipment. Like not the stuff you or I would end up using on a daily basis, but for companies doing stuff. So he wrote those technical manuals, and it came to the point where he insisted. I said, fine. And this actually changed our office policy. We ended up giving him a waiver. Sign this. We're going to give you the word processing document. Go to town. Do whatever you want, but you're taking 100% liability for everything in there. And so if something blows up, it's your fault, not mine. Well, it's not going to blow up. Okay, fine. We gave it to him. He went through, did everything the way he thought it should be done. We had the signing. And I was like, okay, so this is it. We're done now. Yeah, that's fine. Okay. About 3 weeks after the signing, he calls me up because he has some questions. And I reminded him, look, we're done. Well, look, I just need you to explain what this one paragraph means. So he was going back through his signed documents. And I went and I read the paragraph, and I said, well, how am I supposed to know what it means? You wrote it, not me. And I could sense and feel through the phone that he actually understood how badly he screwed up at that point, but we were done. Even if he had come back to us and said, okay, I made a mistake, let's do it. No, we end up doing a lot of work on estate planning as flat rate fees, and in most cases it's covering what my hourly rate is for the work that we have to do. But for him, I joke, I don't even think I was making minimum wage. Well, no, I certainly wasn't making anywhere near what even the most junior attorney just starting out would be making per hour, because I had to put in so many hours arguing with him. We wouldn't have gone back. It's just not a good fit for us as a client. So he realized at that point just how badly he messed up, but it wasn't something we were going to work with. So it's just that I can do it myself. That doesn't end up working out well when you're talking about legal documents. All right, so I'm going to do the general disclaimer before I really jump into this. I don't want anyone taking this video as actual legal advice. So this program is for general informational purposes only and does not constitute legal advice. No attorney-client relationship exists between the user or viewer of this video/webinar. Legal advice and perspectives among attorneys may vary, and legal advice is often different for different situations and for different people and purposes. For specific legal advice related to your particular situation, please contact an attorney in your state or jurisdiction. Copyright 2022, all rights reserved. All right. So let's talk a bit about the main case where this is actually a special needs planning case, an estate planning case, where things were starting out and did very, very well, at least on our end. We got exactly what the client needed. So it was a couple that had a grandson with special needs. They were butting heads with all of the kids. There was one child that they trusted. They may not have agreed on everything with, but this was the person who was going to be in charge, who was going to be the trustee if anything happened to both of them. But they weren't getting along necessarily with all of the other children, especially when it came to that grandson. And they knew there would probably be some kind of challenge to their plan, since they wanted everything, or just about everything, to go to the grandson. But they needed it to be done in a very protected way because, again, he was a beneficiary that had special needs. And by the time he was going to end up being an adult, there would have been programs like disability or Medicaid and other things that he'd be qualified for, where if he got an inheritance outright, that might stop those benefits. Not to mention that, well, I think when they were starting out, they were extremely concerned that he not get control of the money, not because of the way he would spend it. That grandson was actually very frugal. But if he ended up getting involved with someone, they could manipulate him and end up draining the money. And I think that was a little bit more of the issue that they were concerned about, in addition to the benefits. So things did evolve over the years, and there were more things that we had to contend with. So really at phase one, here's what we did. We set up the standard revocable living trust with ancillary documents. So the healthcare power of attorney, financial power of attorney, the pour over will. So it's a will that just, it says, well, it's a last will and testament. Here are the executors. The only beneficiary of this will is the revocable living trust. So we did put in specific provisions that would disinherit the kids. Now, this was not to be mean, but it was the way to make absolutely clear, hey, we're not leaving this for our kids, it's for the grandson. Their grandson was specified as being a special needs beneficiary within the language of the trust, so that it was clear he was not to just get the money outright unless the trustee has this discretion to do that. But they wouldn't do that if it would mess up benefits or they saw that there was a particular threat. And we gave them very specific funding instructions on here's how accounts should be titled, beneficiaries designated to make this whole thing work together. In addition, there's that IRA trust, which would have had that same control, keeping those benefits, but now there were certain tax advantages. So this is just where the tax deferred money would go. Okay. Phase two of the plan, the grandson turned 18. He was living with my clients. So they wanted to make absolutely sure. Plus, there were some, I don't want to give away too much, but there was other money that could be coming in to benefit that grandson. But they didn't want to just put it in his name because, again, there might be benefits that could be jeopardized. So we set up a separate special needs irrevocable trust so that his money could end up going into it if it was allowed, but more so this other money that would be coming in would end up going into that trust, not to the grandson directly, and not through the grandparents, because it wasn't going to be their money. It's the grandson's money. And so this is something that's actually in the special needs planning crash course that we put together. It's part of the Plain English Attorney series. You don't necessarily need a separate special needs trust for a beneficiary that has special needs if it's only your money, because we can set up the revocable trust with the standard language we have and just make it very clear this beneficiary is going to be in that classification, so they're not going to lose their benefits. They're not going to get an inheritance outright. The trustee is going to manage that money for them. You don't need a separate special needs trust if it's just your money. But now with the situation changing, there could be other money coming from other sources, and they didn't want it to go into the grandparents' revocable trust. All right, we set up that separate special needs trust. So that was phase two, really the final planning phase. All right, so this was done over a few years. They spent several thousands of dollars getting all of this done and set up the right way. And then, unbeknownst to me, they hand wrote their own wills and hid them from me. I don't know what it was. I don't know if they didn't want to pay an attorney for their time. I don't know what it was. But they know I would have said don't do it. So they just kind of went ahead and did it without telling me. But they put these wills into their big blue binder with all of the rest of their documents. Okay, so what happened? A few years later, really the husband, he became incompetent to make his own decisions. It was all kind of memory and thought process stuff. Physically, he was okay. There were some minor issues here and there, but he couldn't really live on his own and take care of himself. And with his wife's situation, she wasn't necessarily able to keep up with him and the grandson, and it was just too much. And so the daughter that they trusted started guardianship proceedings. Now, I was kind of in a bind because if I were to step back and look objectively and say, oh, well, maybe it is better, and again, just speculating, maybe it is better that the daughter be in charge. That's not what attorneys do. I work for my clients, and even though it appeared to me she might have been taking on too much, the wife was still fully competent. She was still able to make her own decisions. And when I spoke about it, I said, do you want to take your daughter out as that trustee? She's like, no. She's still the best option after me. Okay, so we left everything the way it was. And again, she never mentioned those handwritten wills. So we got notice from that daughter that mom had passed on. She had gotten guardianship over her father, and in fact, I believe she ended up getting it before mom even passed on. And now she was kind of gathering things up, and it's like, all right, what do I need to do? I know they had this trust. I know you were the attorney. She was part of the initial planning process to give her the kind of briefing. We call it a family review meeting. So she got the basic overview years and years past, but now she was trying to get things together, and she discovered these wills. She's like, is there anything I need to do with it? I'm like, okay. I ended up sending a scan of the will over to the attorney that we're usually referring all the probate work to. And she's like, well, yeah, it looks like a valid will to me. It's gonna have to be probated. So here we were. We have the revocable living trust. The husband, my client, is still the beneficiary of that trust. So all the assets in that trust are for his benefit, but now because he's not competent to handle the job of trustee, that daughter is now in charge as the acting trustee. We have the IRA trust, which doesn't have anything in it, or at least it shouldn't. We never advised them to. It's set to be the pay-on-death beneficiary of any IRAs or 401ks and other tax-deferred or tax-free accounts to maximize tax savings. And then there is that special needs irrevocable trust. It was kind of irrevocable from the minute something went in it. So there was that trust. It's separate. Money should have gone into it. Again, we set this up and then they didn't communicate with me about any of that stuff after the fact. So that's irrevocable. So all of those components were there. They were all doing exactly what they did. But now here's kind of what the fallout ended up being, because now there was a valid handwritten will. It directed the house and a money market account to go into that irrevocable special needs trust. Okay? But then the very last line before they signed it: this negates all other wills and trust I have previously signed. That sounds like revoking the trust and revoking their will. So, all right, what are the results of that? What is the implication if that is determined to be the case? And I'll explain why some of it is or isn't the case. All right. The pour over will. Even though that was signed, witnessed, and notarized, this handwritten will is dated after that signed, witnessed, notarized will that we prepared and put together. So that is probably throwing that out. And since this new will doesn't contain anything else for what may end up in probate, okay, it goes according to intestacy. So if there is an account outside the trust, other than that money market account that's addressed in there, it goes to the kids equally. But they wanted it to go to the grandson. Well, yeah, but no, that's not what happens. If it is the money market account and it's not in the revocable trust as we advised, well, okay, then that goes to that special needs trust. Not an issue. The house, that needs to go there. Well, last I checked, the house was in the revocable living trust, and it had very specific terms which secured it within the revocable trust after both the husband and wife died, for it to be there for their grandson and in the hands of the trustee. Okay, well, if it's revoked, well then, okay, then the house would end up going to that special needs trust. But here's the whole big question that's probably gonna have to be determined by a court. Is the revocable trust revoked? And if it's revoked, then all of those assets end up being dumped 50-50 into husband and wife's name. So now half of everything that they had in the revocable trust, in order to avoid probate, is going to end up being part of the wife's probate. So, okay, so they wanted to initially avoid probate and avoid some of the vulnerabilities that come around with probate, including, oh, there could be a contest, and contests tend to be easier because they're within that probate process. That's all that vulnerability is back on the table. However, we craft and write the revocable trust, all of them, in a way that the trusts are signed, witnessed, and notarized. At least all the trusts that we've done, I think from like 2009 forward. And there are a few that were simpler ones that my clients may have updated. But anyway, it's got to be signed, witnessed, and notarized. And if the trust is going to be amended in any way, it's got to be signed, witnessed, and notarized. These wills did not have any witnesses or notaries. So if I were forced to make a bet, it's that the revocable living trust wasn't revoked by that sentence, just because the terms of the trust make it clear how it's to be amended. But again, in the end, it's up to a court on how that's going to end up being treated legally. Was the trust revoked by that will? I can't and won't speculate on this very specific instance beyond what I've already said, just because it's going to have to be determined that way. So yeah, there's a lot of potential fallout here. So if that trust does end up being revoked, well, then half those assets end up right in probate, and now we don't have a revocable trust for the husband. So if anything happens to him, his half of the assets are going to end up in probate as well, and it's just kind of a mess, all because they didn't want me to handle whatever the paperwork or pay for whatever the questions to be answered would have been. They had a solid plan, except they just went off the rails with this one thing. But that one small thing could be enough to undo everything. So that's really the cautionary tale here. Don't just do it yourself if you're going to end up just negating stuff. You know, unfortunately, I do have a few other clients that just want to go ahead and do that themselves. Oh, I can handle it, and it's just going to end up being a disaster. So we do have some other resources that are out there. There's the Plain English Attorney series at plainenglishattorneyseries.com. That gives you access to all of our courses that are online, and we're adding new material all the time. In fact, we got another course that should be coming in hopefully soon as of the date of this video. And if it's just the estate planning, well, there's the estatecrashcourse.com that you can go to, and that's got that program. And we're hoping sometime in the next several months to have a separate kind of ongoing webinar related to just avoiding probate and the basics of estate planning. So I hope you found that information useful. If you haven't subscribed to the channel, please go ahead and do that. It helps out quite a bit. Subscribe to the channel, like the video, turn on the notifications so you know when you're getting this information when it comes up. It's on a weekly basis, if not more, depending on how many videos we got. We may be able to put out 2 a week. So as I'm always telling my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.